I'm John Malcolm. I'm the chairman of the Criminal Law Practice Group. I'm delighted that you are here with us. I have the privilege of introducing our distinguished moderator today, which posed the problem to me of how do you introduce somebody who truly needs no introduction, especially to this group. You know, all of you know that Ed Meese is a close friend, or was a close friend and advisor of Ronald Reagan, and that he served President Reagan and our country ably as counselor to the president, and then as our 75th Attorney General of the United States. All of you know that Ed is the Ronald Reagan Chair of Public Policy at the Heritage Foundation and a distinguished visiting fellow at the Hoover Institution. What some of you may not know, or may at least have failed to recollect, is that it was 25 years ago this year that General Meese gave a landmark presentation about the jurisprudence of original intention, in which he criticized judges for seeming to roam at large in a veritable constitutional forest. He called upon judges to judge policies in light of principles rather than remold principles in light of policies. Whew, what a radical. Actually urging judges to pay proper respect to our Constitution as it was written. A new wind, really oxygen in a mine shaft, blew through legal circles, including legal academies. This prompted Justice William Brennan to give a speech labeling originalism as little more than arrogance cloaked as humility. The debate started then, of course, continues to this day, but the fact that we have this debate and that the views of the originalists are taken seriously and respected is truly remarkable. Now it's my pleasure to introduce one of the guiding spirits of the Federalist Society, General Ed Meese.
Well, thank you, John, and thank you, ladies and gentlemen. It's always a great pleasure to participate in the activities of the Federalist Society, and particularly this particular conference, which has every year drawn more and more lawyers from throughout the United States, people who, many of you, I know, started your activities with the Federalist Society while in law school and continue being part of the lawyers' chapters throughout the country. It's a real tribute to the founders who are here. I think almost all of them are here, who started something totally new in the early 1980s, and to see it blossom into this really outstanding organization of lawyers, which it is today. Our topic today is the expansion of federal criminal power, too much or too little. In 1998, the American Bar Association, actually a few years before 1998, put together a task force on the federalization of crime, which culminated in 1998 with their report. Three of us here on this panel were part of that task force: John Baker, Sara, Beale, and myself. And which is an indication that this is not a new topic. Indeed, it goes all the way back, if you really think about it, back to the founders. And the founders were very much concerned about this whole conflict between a government that was sufficiently energetic, as they called it, to carry out the functions of a national government, as opposed to the potential for oppression of the people and for intruding on the liberty of the people, and in effect carrying on again in the new nation what they had suffered under George III from Britain before the War for Independence. And so this conflict is going on. But the one thing that has changed, I think, more than anything else in terms of federal power has been, over the years, the development of federal power in the criminal law, which was almost unheard of in 1787 when the Constitution was drafted. In those days, the crimes were primarily things like treason, piracy, things such as that. There were very few federal crimes. Indeed, there were very few criminal prosecutions in most of the early days of our country. Today, of course, as our task force found out, At that time, I believe they found that there were some 4,000 federal crimes, most of which had been passed by Congress in recent years. They also found out that there are more than perhaps 10,000 criminal acts, much of which can be found only by looking in obscure places such as the Federal Register, because they are regulations passed by or promulgated by regulatory agencies, the violation of which, if you go back to the statute enabling them to do that, the regulatory agencies to do that, violation of those statutes is in fact a crime. And so we have a broad range of crimes now. We also have the problem, of course, as you do with any criminal statute, there's a great deal of vagueness in many of the crimes, such as the Foreign Corrupt Practices Act, which has many aspects to it, the Honest Services Act, which was recently found to be unduly vague by the Supreme Court, and so on. The expansion of federal power and the critique of it usually falls into two categories. One is the federalization of crime, that is, taking matters that everyone recognizes as crimes and which have traditionally been enforced by local and state governments, things like murder, robbery, rape, and the normal lexicon of criminal offenses, and then Congress passing a statute. It usually happens when there's been some headline-grabbing type of offense, some particular crime, such as carjacking, if many years ago was a headline-type offense, and so lo and behold, we had a federal crime of carjacking. Now, to say that it was unnecessary is an understatement, because we had, in every jurisdiction, every state jurisdiction, we had ample laws against carjacking, the combination of robbery and auto theft, which were being vigorously enforced by local prosecutors. But because it was a high-profile series of events, Congress passed a law making for federal carjacking. Since that time, there have been very few carjacking prosecutions, because most of these have been handled, as they always were, by local district attorneys or state attorneys. The other category, of course, are those matters, many of which no one would think of as criminal, which are more regulatory, administrative matters, environmental matters, and the like, where special interest groups often prevail upon Congress to show that this is an important matter, and it's to illustrate that it's important, attach a criminal penalty for its violation. And so that's why we have so many of these federal crimes, many of them totally obscure, many of them almost unintelligible in terms of the average person who might be an offender, thinking of it as criminal conduct. So that's kind of the background in which today's topic is brought before you, and that is, again, expansion of federal criminal power, too much or too little. We have an all-star cast to discuss this, people who have been working in these fields and who are going to enlighten us on their various points of view on this. Our first speaker will be Professor John Baker. John, as I mentioned, was a part of our task force in the 1990s. He's the Dale Bennett Professor of Law at the Louisiana State University Law Center. John has an interesting hobby. It's going around speaking at law schools. He has spoken at over 100 law schools in this country and elsewhere. I won't read all of them where he's been, but he has been, just to illustrate though, he's been in the Philippines in the law school there, or actually he was a Fulbright scholar there, and where he lectured, and he was also a lecturer at the Hong Kong University. His list is so long, as I say, I won't mention it, but he certainly lectured in places where I didn't even realize they had law schools. He's been an assistant district attorney. He's been a consultant to the Justice Department, to the Senate Judiciary Subcommittee on the Separation of Powers. He's worked as a consultant in the White House, at the United States Information Agency, and in the United States Agency for International Development. So he has a great background in this. Next to speak will be Noah Bookbinder. Noah is the Chief Counsel for Criminal Justice on the Senate Judiciary Committee. He is a principal advisor to Congress through that position on a variety of criminal justice issues. He also works on, and has worked in regard to judicial and executive nominations, an important part of the Senate's work, and particularly the Judiciary Committee, which probably has the major workload on that subject. And he has been a trial attorney in the Department of Justice's Public Integrity Section, which has the responsibility of investigating a lot of the federal crimes, particularly those relating to federal public corruption cases, including bribery, contracting fraud, and many other related subjects. He is a graduate of Yale University and Stanford Law School. Next to speak will be Brad Berenson. Brad is a litigator here in Washington, D.C. His work focuses on white-collar criminal cases, of which there appear to be no lack of business, particularly in recent years. But he also has a rich background in the federal government. He was associate counsel to the President of the United States, and in that regard dealt with a number of topics relating both to the executive branch of government, a number of things relating to the President's war powers and homeland security, as well as dealing with matters such as the ones we're talking about today. He's a graduate of Yale University and Harvard Law School, and he clerked for Judge Silberman and Judge Kennedy on the Supreme Court. And then finally, our speaker, again, also as I mentioned, a member of our task force, is Sara's son Beale, who is one of the reigning experts on this subject. She is the Charles Lowndes Professor at Duke Law School. She has written extensively on all aspects of federal criminal law and criminal law generally. She's also been active in law reform movements, particularly relating to the federal government's role in criminal justice matters. She's a reporter for the Judicial Conference Advisory Committee on Criminal Rules, and also she has taught extensively, not only at Duke, but also throughout the world and in various countries, although she has been taught primarily at those law schools in countries that relate to the common law, although also Spain, Switzerland, and Taiwan. She is a graduate of the University of Michigan, clerked on the Sixth Circuit, served in the Office of Legal Counsel and the Office of Solicitor General. From this description of our four speakers, I think you can see that they have had considerable experience from various vantage points to talk about this important topic. And so with that, please join me in welcoming John Baker.
Thank you, General Meese. The Supreme Court has on its docket this year a case that illustrates all of the constitutional issues that are raised in this context, plus a new one that I'll talk about just briefly. Bond versus the United States has a set of facts that is perfect for a made-for-television movie. You might call it The Real Desperate Housewife. Mrs. Bond attempted to poison her best friend. That is, her best friend until she found out that the friend was pregnant with Mr. Bond's child. Now, she attempted to poison her 24 times, which might suggest that she was not terribly competent, but in fact, it turns out that she was a trained microbiologist, and she had selected chemicals that were able to produce toxic effects with small contact. So she sprinkled the chemicals over the doorknobs of the house, the car handles of the car, and over the mailbox. And the mailbox got the Postal Service involved. Now, it is clear that Mrs. Bond is guilty of many crimes. She at least was guilty of one aggravated battery and at least 23 or 24 attempted aggravated batteries, and arguably attempted murder, depending upon whether she merely wanted to hurt the woman or kill the woman. Now, in all fairness to the Justice Department, this is not a case that they went out and snatched. In fact, local law enforcement was not terribly helpful, and Mrs. Bond went to federal authorities. Nevertheless, when you look at what she got charged with, you have to wonder, why would you charge this woman under the chemical weapons statute passed pursuant to the Chemical Weapons Treaty. Why would you do that? Well, it was convenient. And when you look at the statute, you'll realize that it fits. The problem is it fits all of us. Now, the Supreme Court has really only taken the issue of whether she has standing under the 10th Amendment, as the district court put it, to challenge the statute, because the government is saying, look, this statute was passed pursuant to a treaty, so we don't really need any particular power. The treaty power and the necessary proper clause are sufficient. But let's look at the basically three constitutional issues that this case raises beyond that. One is federalism, and two is due process / vagueness, vagueness, and the third is separation of powers. The government said that it was not necessary to have any limitation in the statute regarding a federal interest. It was sufficient that her conduct simply literally fell within the federal, within the wording of the statute. Well, obviously, that presents a problem if there's no limitation when you actually read the statute. And that's the second point about due process and vagueness. The statute tracks pretty much the treaty, except it adds the word knowingly, which we'll see is not terribly helpful. It includes or applies to anyone who, quote, owns, possesses, or uses, okay, what? A chemical weapon. Boy, that sounds scary, doesn't it? Well, what is a chemical weapon? Any, quote, toxic chemical. What is a toxic chemical? Any chemical that can, quote, cause death, temporary incapacity, permanent harm to humans or animals. That's it. Now, as the Third Circuit recognized, this does cover many of the cleaning products found in the typical local grocery store. So anyone who owns, uses, possesses Lysol is literally covered under the statute. Well, doesn't the intent requirement save this? Clearly she had intent, right? Well, the intent is knowing. Knowing what? Knowing that you possess it. Knowing that you use it. That's not much protection when it comes to mens rea. Well, what about separation of powers? Well, this, and Noah, I'm sure, is going to not be happy with this, but you know, what it really comes down to is a complete failure of Congress, Republican and Democrat, and probably more so Republicans, actually, because as I like to say, Republicans are opposed to regulation until you put a criminal penalty on it, and then they're all for it. The problem we know after the health care bill is that members of Congress don't read what they vote on. And it's bad enough that they don't read ordinary criminal statutes, but a treaty is not drafted as a criminal statute. So when you just take the treaty and add knowing in it, it's not a big help. Moreover, the real serious concern that I have about separation of powers, and I raised this with Noah ahead of time, was that the Justice Department continues to detail its attorneys to work on the staff of the Judiciary Committee drafting legislation. It is one thing to draft it, hand it to a member of Congress, and go testify in front of the dais. It is another matter to work behind the scenes. There couldn't be a clearer violation of separation of powers than that interchange between the two branches that the framers clearly wanted to stop, because that's the kind of corruption that they were very much opposed to. The executive branch, under all presidents, unfortunately, is not very much help, because the Justice Department wants as much discretion as possible. And of course, they always say, trust us. The framers didn't trust themselves. I have no doubt about the good intentions of every prosecutor, well, most every prosecutor. And good intentions are not enough, because the framers understood, and I don't think anything has much changed except maybe it's worse, that politics is about power. And human beings, even with the best of intentions, will abuse power unless you stop it. Sara and I were on a panel not long ago, and one of the other panelists who was formerly with DOJ said, look, what the framers did, thought, what's in the Constitution, when it comes to this stuff, it's basically irrelevant. We've got to do what's necessary. What the framers did was to do what's necessary to stop the abuse of power. The judiciary isn't any help much unless you get your case to the Supreme Court where you've got your best shot. Because the lower federal courts don't much, except in a few instances, want to say that a statute of Congress has to be narrowly construed or it has to be declared vague or otherwise unconstitutional. The reality is that strict construction doesn't mean a whole lot in the federal courts, but strict construction is not merely a maxim of construction. As Chief Justice Marshall said in the Wiltberger case, strict construction is a matter of separation of powers. It is not up to the courts to write the statute, it is up to the Congress to write the statute. In conclusion, if you watched the news this morning or if you read the papers, you know that yesterday in New York there was not a very good result when a foreign terrorist, or at least charged as a foreign terrorist, was convicted on only one count out of over 285 counts. Of course, many of us thought that it never should have been tried in an Article III court in the first place. But not to worry, not to worry. There is still plenty of opportunity to have successful prosecutions of homegrown terrorists as long as most Americans continue to buy Lysol and other chemical weapons. Thank you very much.
Thank you, John. Now please welcome Noah Bookbinder.
Thanks a lot. I should start by noting that my boss, the senator that I report to directly, Senator Patrick Leahy, is a former state prosecutor, and in that guise is somebody who is very sympathetic to, and I think in a very personal way, to the importance of not having excessive federal intrusion into areas, particularly areas in the criminal law that have been traditionally handled by the states. He's somebody who is concerned about federalization where the states are capable of and are the right people to handle prosecution, as well as about reflexive and excessive creation of new crimes. And so I think that's something where his view is, and my view is similar to a lot of the other folks on this panel. And I think that's particularly true in cases of drug crime, street crime, the traditional core areas of public safety that have always been the responsibilities of the states. Although it's interesting that discussion of these issues rarely focuses on those areas. I found it interesting actually at a recent House hearing on overcriminalization that Congressman Gohmert, the ranking Republican in that in the crime subcommittee over there, made the point that in his view there are too many people in federal prisons for drug offenses. I think that's not something you hear very often, but is a logical extension of this argument. And because that's who most of the people are in federal prisons. I think that fraud and corruption, white-collar offenses, which is what you do usually hear about, is really a different case. Federal prosecutions are most important in those areas where the states are least able to investigate and prosecute serious conduct. And in the case of fraud and corruption, the states often simply don't have the resources and the expertise to bring these kinds of cases. That's not, of course, true across the board, but it is true in a lot of cases, particularly in this time of state budget crunches, where state district attorneys' offices are less and less able to bring prosecutions outside of the core public safety area. So often they simply just don't have the resources to bring complex fraud cases, complex corruption cases. They also often don't have the expertise because they don't see that many of these cases, whereas in U.S. attorneys' offices and in Main Justice in Washington, you have people who have seen these kinds of cases again and again, really know how to do them, where there is serious and important fraudulent and corrupt conduct that needs to be addressed. The Judicial Conference, which often is skeptical about federal criminal statutes, has taken the position that fraud and corruption are a different case in an area where it is appropriate to have real federal involvement. Corruption cases also present a further hurdle for state and local prosecution in that it is common to have personal relationships, conflicts of interest, power dynamics that make it difficult for local prosecutors to bring corruption cases against local officials. Not that these kinds of issues cannot show up in the federal context, but they're more rare and more easily controllable in the federal context. At a recent Senate Judiciary Committee hearing on the issue of honest services, which has been alluded to, Senator Sessions, the ranking Republican on that committee, talked about, from his experience as a U.S. attorney, the fact that corruption, local corruption, often is not dealt with effectively at the state and local level, and it's really important to have a strong federal presence there. All of that said, statutes, federal criminal statutes, have to be well thought out and they have to be well drafted. They should address specific needs that have been identified by investigators, by prosecutors. They should be narrowly tailored. They should give fair notice to the people who may violate them. Obviously, I think everybody will agree that has not always been the case. And in those cases where federal statutes have been drafted in a way that's overbroad, that's something that ought to be addressed. Of course, the fact that it hasn't always been done well doesn't necessarily mean you shouldn't do it at all. It means you should do it right. I think that's what Senator Leahy on the Judiciary Committee has tried to do. He is somebody who has legislated in recent years in the fraud and corruption areas and has worked hard not to craft sweeping new laws or laws that in a very broad way respond to the news, but rather narrow, well thought out fixes to specific needs, done on a bipartisan basis, and hopefully done carefully. Honest services fraud is obviously an area that's gotten a lot of attention with the Supreme Court's Skilling case in the spring. The honest services fraud statute is one that, particularly in the public sector, but also in the private sector, for well over 50 years, did fill a significant need, did enable the prosecution of important and serious misconduct. And I'm happy to get into this in more detail later if people are interested. It clearly, as identified by the Supreme Court, was a statute that had some problems. While it tapped into a body of case law, it was not clear where the contours of it were, and that allowed for potential misuse. The court's case, the Skilling case, which responded to those problems by substantially narrowing the honest services statute, did leave a major gap in conduct that has in the past been addressed by federal prosecutors that is truly akin in seriousness and in nature to the kind of conduct that the court did leave. It simply has a somewhat different kind of technique in the corruption. And the solution to that, certainly in Senator Leahy's view, is not to say, forget about it, this conduct isn't serious, we shouldn't address it, nor is it to say, let's go back to where we were before. It's to say, all right, let's actually get it right and try to define very carefully and appropriately the conduct that we are getting at. That's what the legislation that he introduced tries to do, and an approach that ought to be useful at a time when corporate fraud is more of a problem nationally, arguably, than perhaps it's ever been. Public corruption is common in a lot of branches of government. We should tackle these problems, but we should do it right. We should do it narrowly. We should do it carefully. Thanks.
Thank you. Our next speaker will be Brad Berenson. Please welcome him to the platform.
Thank you very much, General Meese. Greetings to all of you. I'd like to take my few minutes here at the podium to shine a light on what I think is an underappreciated aspect of the overcriminalization problem. And not only is it underappreciated, it's actually one that I think poses a larger threat to the health of the body politic as a whole than a simple focus on something like the honest services fraud statute, which may be unduly vague, or on public welfare offenses, which have watered down mens rea. The aspect of overcriminalization that I'd like to talk about for a few minutes here has to do with corporate criminal liability. With respect to the topic of today's panel, too much or too little, I'm very much on the too much side. We have far too much legitimate, ordinary business conduct that is potentially subject to the reach of the federal criminal law. As General Meese noted at the beginning, a lot of the criminal statutes, of which there are thousands, and not just in Title 18, incorporate wholesale not only the body of federal regulation, but even in many cases, things like various federal permits. You can have a 50 or 100-page Clean Water Act permit that the Army Corps of Engineers has drafted up, many of whose provisions are so picayune that it would never occur to anyone that violation of them could be a federal criminal offense. And yet the way this all works, the way the statute works, any violation of any provision of that permit could be a federal crime. And so the universe of conduct that is covered by federal criminal statutes is almost literally unlimited because it is subject to expansion by the bureaucracy through the creation of these permits, not just the regulatory process. Typically, so much in certain industries, heavily regulated industries, think pharmaceuticals, for example, the level of regulation is so heavy that it is literally impossible for any large, complex business enterprise to be in perfect compliance at any time. And so every company in those areas is always potentially subject to federal criminal investigation or prosecution. You have the nightmare scenario that I think it was Justice Jackson talked about a half century ago, where the prosecutor doesn't have the crime and goes looking for the criminal, but rather can just decide on a criminal and go looking for the crime. And this happens. There are U.S. attorneys' offices around the country that consider themselves specialists in certain categories of white-collar crime, and they literally just start subpoenaing documents from any company they want looking for these problems. They will always be found. Now, the background rules of the substantive law, the watering down of mens rea, the fact that corporations are vicariously liable for the acts even of rogue employees who are violating corporate policy is bad enough. But what is worse, and what really makes this a pernicious problem, is the fact that corporations, to a very great extent, have now lost their trial rights. They have lost their ability to go to court and vindicate their positions when they believe they're correct about a proposition of law or of fact that is in opposition to the government's view. Why? Largely because of suspension and debarment. Any major corporation that does a significant amount of business with the U.S. government, immediately upon indictment, not upon completion of the trial, not upon conviction, but upon indictment, becomes subject to permissive exclusion from federal programs. If you're a pharmaceutical company or a healthcare company, that's a corporate death sentence. If you're a defense contractor, it's a corporate death sentence. If you're in a wide variety of other industries, even the automobile industry, which may sell a lot of cars for the federal fleets or trucks to the Postal Service, it's either a federal death sentence or close to it. If you took an indictment as a company, your stock would drop so precipitously the day after that immediately the board of directors would be involved and management would be getting grilled and probably fired. So what this sets up is a dynamic where prosecutors have all the power in these discussions. They have the whip hand, and they have the power to extract extortionate settlements from companies, even in circumstances where those companies and their counsel know, or at least believe, that they have not in fact committed the crime that the federal government is accusing them of. This is often also done through deferred prosecution agreements or non-prosecution agreements, which, unlike a guilty plea, are totally outside any sort of judicial supervision. And so really what we have is the separation of powers completely unbalanced and knocked out of whack by the combination of proliferating federal criminal statutes and these rules that make it impossible for companies to defend themselves, but rather just put them in the position of supplicants pleading with prosecutors or their superiors to be reasonable and not extract too much money. Now, why did I say at the outset that this has larger and very negative implications for the body politic? Well, there are horrible practical consequences to a situation that is this pervasively unfair. The first and most obvious, of course, is that it imposes enormous direct and indirect costs on businesses in the United States, not just the costs of settlement and the costs of counsel, but increasingly the costs of investigation and the costs of post-agreement monitoring are being imposed on the companies themselves. There are situations where companies may engage in conduct that most of us would agree is relatively minor in the scale of malfeasance that end up costing tens or even hundreds of millions of dollars. There's also an increasing trend toward the imposition of so-called monitors on corporations when they enter into these agreements. Basically, this is an in-house prosecutor. This is a representative of the government who sits inside a company, monitors and oversees its operations, reports regularly on how well the company is doing, and if you think they narrowly confine their mandate to legal compliance in the narrow area that was the subject of the agreement, you're dreaming. These people have enormous power. Companies, as a practical matter, pay a fearsome price for pushing back against them and are very intimidated and frightened to do that. So you essentially have a deputized federal prosecutor running loose inside these companies. This creates an enormous chill on legitimate business conduct. It diminishes foreign direct investment in the United States. I had the general counsel of a very large British company tell me just a few weeks ago that 80% of the time that is spent in the company's audit committee meetings is spent on U.S. litigation problems, whether criminal investigations or civil litigation, 80% of the time. And he said that company will never consider expanding its operations in the United States as a result. Yeah, they'll always need to sell here, but where are they going to build a plant? Where are they going to create jobs? Not here. There are also companies delisting from our stock exchanges and hurting the competitiveness of our financial markets. A very large German pharmaceutical company in 2007 delisted from the New York Stock Exchange for precisely this reason. I think uppermost in their mind was Sarbanes-Oxley at the time, but it might just as well have been things like the FCPA, where the view of jurisdiction in the statute is so broad and the conduct, as General Meese pointed out, is so amorphous and so comprehensive and in many respects so minor that the company is under constant threat of federal criminal investigation, particularly if it has shares listed here that's subjected to literally strict liability for these offenses. So it severely hurts American competitiveness, severely hurts business, and does not, I think, produce a corresponding benefit in terms of corporate conduct or legal compliance. After all, corporations are subject to civil liability, and on the criminal side, the penalty is the same. It's money. What's the difference between having to pay dollars civilly and punitive damages if your conduct is bad enough, or criminal conduct? It's the stigma, it's the moral aspect, and it's the awesome power of the federal government's investigative and prosecutorial machinery. We don't need it by and large. During the discussion, if people are interested, we can talk about ways that it could be limited and cabined into areas where it's more appropriate. But my basic point is that through the proliferation of federal criminal law into the area of business crimes and corporate conduct, we are slowly strangling the goose that lays our golden eggs and doing it in the name of law enforcement. Thanks very much.
And finally, our cleanup speaker here, Sara Beale. Please welcome Sara.
Thank you. It's really a privilege to be at this meeting and to speak to this group and to be back with General Meese and John. We were right when we issued our report. We're right now. We're probably more right now than we were then. So the basic theme that most of the speakers have agreed with is that federal jurisdiction is too broad. That's the right part. What does that mean? And you're going to be able to tell that I'm going to part company somewhat with some of my colleagues up here in terms of what that means. And it probably means I'm going to try to stake out a position in the middle. That will mean I get hit by traffic coming both ways. You're sort of like that skunk in the middle of the road that gets hit by traffic coming both ways, and everybody thinks it smells bad. So I may try to stake out this skunk position here. So federal jurisdiction is too broad. What does that mean? Well, there are way too many offenses. You know, it is ridiculous to be talking about thousands of offenses and then offenses backed up by thousands of regulations. So why are there too many offenses? There's some things that shouldn't be federal offenses. They should be state offenses. There's some things that are already federal offenses, and we don't need 2, 3, 4, 5 more variations of that. Maybe the original offense needs to be modified in some way, but there's this kind of proliferation that occurs, and that does help to lead to more leverage on prosecutors' parts as they stack these counts in an indictment. There's a kind of in terrorem effect from that. There are some things, I imagine, that probably shouldn't be a crime at all, and therefore shouldn't be in the federal code or the state code, and we need to talk about what those things are. For example, is it corporate criminal liability or not? And then there are too many, the consequence of having too large a number of federal criminal prosecutions is something that we really haven't yet talked about this afternoon, which is that we create a situation where federal jurisdiction is about 10 miles or 100 miles wide and about an inch deep, which means that it can only imaginably be enforced in an extraordinarily sporadic and uneven way. So in fact, most of us really don't need to be worried about our Lysol. I'm not worried about my Lysol. I don't know about you, but I don't think you really should be worried about your Lysol. But it could be prosecuted, right? And who decides that? And that is extremely problematic, even in the cases where the underlying behavior probably should be criminal. The fact that the government will every once in a while single out one of those cases is very problematic to me, and I hope to convince you that it is as well. So we need to think about how the code should be narrowed, what should be some of the factors. John's already talked about the historic basis, the kind of constitutional framework. How about also thinking about the size and capacity of the federal courts and the federal government's enforcement authority? If we have a system that does only prosecute about 5% of the felonies, even if you doubled it, it would be 10%. It's going to be a small, limited, and hopefully then appropriately employed prosecutorial authority. So we need to think about the unique advantages of federal prosecutors, federal courts. What can they do well that state authorities cannot do as well, or maybe can't do at all? State authorities, for example, really are unable to respond to international conduct, a conduct that spans several states, and so on. And again, it is a small system, so we really, I think Noah is exactly right. We need to be smart about what we do, right? And we just can't think that we're going to do everything, and Congress needs to restrain itself. You know, another statute that kind of sounds good on its face, it really needs to be compared to what are the alternatives. So besides the inherently limited scope and nature of the system, what else should we think about? Well, we should think about the need to protect the public. right? And Noah talked about the fact that there may be a justification for statutes that are aimed at public corruption, that that's a serious kind of cancer gnawing at the body politic. So what are the different kinds of forms of conduct that impose a great enough danger to the public that we really think that belongs on our agenda? So that should be part of our analysis. So the distinctive nature of the federal government's authority and ability to prosecute, the importance of the conduct involved, and I think we should put some other factors on the table. The values that we want to see employed here, fair and equal treatment among cases. The federal sentencing guidelines were adopted in part because of, I think, a correct perception that individuals who did the same thing, had the same background, should get the same treatment, right? They should get the same sentence. They shouldn't get twice as long here and half as long there with no way of being able to explain that. One of my concerns is that if you have a criminal justice system that's 10 miles wide and a quarter-inch deep, and you just pick an occasional case here and there, all the remaining cases that stay in the state system get completely different treatment. Right? It's like a kind of a lottery where you pull out a few cases and those are treated in an extraordinarily different fashion. And I think we ought to talk about the size of the problem. What are the kinds of issues that we as people who are thinking about reforming the system really ought to focus on? What are the big problems as opposed to what are the small problems? So Noah and Brad have suggested that one of the issues is the prosecution of corporations. That's an issue that Brad wants us to think about. That is not where I would start on a reform agenda. Why not? Okay, so number one, it's a tiny, tiny, tiny number of cases. In the past 15 years, we have not had more than 200 corporations prosecuted. Brad correctly referred to the fact that not all of the cases involve formal prosecutions. You might have DPAs, NPAs. You have maybe 10 to 20 of those per year. It's not a large number of the cases in the system. If we're talking about the 4,000 crimes and the hundreds of thousands of people in federal prisons, the getting near to 100,000 prosecutions per year, what are those? They are not corporate prosecutions. And I think I am persuaded that there actually is a need to have in the toolkit, or the tool belt maybe, the tool belt or the toolkit, corporate criminal liability as one of the various sanctions that can be employed. Brad correctly talked about the fact that it's not the only one. Right? You have upfront regulation, you have civil liability. We've actually pruned back quite a lot of our options on the civil liability side, and it might be time to take a look at that balance. But we do have corporations that wield enormous power, that have tremendous capacity to wreak harm, whether you think about it in terms of environmental health and safety. Think of the damage caused by the Gulf oil spill, mine collapse, and so forth. We need to have corporate criminal liability in our toolkit. And again, we need to think about how to regulate, how to tweak that if necessary in a way that is appropriate. If we look at if we take an international comparison, Brad said that companies that are involved in economic behavior in a variety of countries, what's happening in Western Europe? They're creating and they're broadening. They're creating and they're broadening corporate criminal liability. They're not eliminating it, they're not narrowing it, they're creating it and broadening it. I've got several articles on this if you want to read them. I won't go into details now. Corporations do face tremendous leverage from prosecutors. Very few of them go to trial. It's true of other criminal defendants in the federal criminal system. I sometimes feel like the white-collar lawyers actually think they just discovered gravity. It falls, right? They need to talk to people that represent defendants in drug and firearm cases and the other cases that make up the vast bulk of the criminal justice system. Fewer than 4% of federal crimes go to trial. If you face the mandatory minimum, you can't afford to go to trial. The only way to get below that and get acceptance of responsibility and, in fact, cooperate with prosecutors, plead out. We do have a system where there is tremendous, perhaps excessive, leverage employed by prosecutors. We ought to think about it. It's not distinctive for corporate criminal cases, in my view. Sentencing is too draconian. That's not distinctive when you look at white-collar or corporate cases. We really need to think about that when we talk about drug, firearm, and other kinds of cases. What is the balance? What is the right balance? Are we seeing canaries in the coal mine? I sometimes think the white-collar guys who do such an effective job, Brad was really effective, do such an effective job highlighting these problems, and their corporate clients and their white-collar clients are like the canaries in the coal mine. They are showing us there are some significant problems here that need to be addressed. But I would hope that we wouldn't just fix those problems. What about the prosecution of political corruption? I think there is a role for the federal government there. I think 1346 probably should be amended and broadened. I do not believe that we should limit our federal criminal jurisdiction to cases that are, quote, bribes and, quote, kickbacks. We don't know exactly what that is, but I think that the federal interest and the need for someone other than federal, local, and state enforcement authorities is needed. Think about the question whether state and local authorities effectively can prosecute a corrupt governor. And if the answer to that is not very easily, not very well, maybe it'll happen once in a while, but it's more likely to happen with federal authority backing that up, are you really only concerned about things that are formal bribes and kickbacks? And I think the answer may be no. The Wyrick case that was in the Supreme Court was not a governor. It was members of the state legislature. Bruce Wyrick was a member of the House in Alaska. He sat on their ethics committee. He was a lawyer, is a lawyer. He wrote to Vico, one of the big oil development companies, soliciting legal business when he left the legislature right before he voted on the re-regulation of the oil fields. That was directly within the scope of Vico's major business enterprises. Was there a blatant conflict of interest? Was there a sort of, not an express quid pro quo yet, but did it show a breach of his duty of honest services? Do you really want to limit this to bribes and kickbacks? Is that, in fact, a good measure? What if it's a tiny little bribe on the part of, I don't know, a meat inspector or some other local authority, but it is a bribe and there is enough of a basis for federal jurisdiction? I think that we do need to be smart about this, and there is a federal role. What about the drug and firearm cases? Those are the big numbers. Aren't those cases where we really ought to think about whether it should be a crime at all? Should it be a crime at all? And if so, how should we define this? And should it be in federal court? It's a very large number of cases, huge fairness questions. Defendants that are brought into federal court generally get much longer sentences. They have less access to pretrial diversion. The average defendant sentenced to drug trafficking between 2001 and 2006. His sentence substantially exceeded those people convicted in the federal systems. These are federal defenders, convicted of manslaughter and assault, and in most years it exceeded the sentence for people convicted of sexual abuse and arson. Right? Are our sentences too severe? Are we pulling people in who don't need to be in the federal system? Should we be looking at that? I think, yes, we should. Notice when you pull these few cases, you select a few drug cases, a few firearm cases, you pull them into the federal system, you're doing a kind of forum shopping that typically exposes those defendants to a much longer sentence. They kind of win a bad lottery. Right? And you compare their sentences to all other federal defendants, and you're supposed to get the same sentence as all other federal defendants, but really all their peers are in the state system, getting a substantially different sentence. I think that should be on our reform agenda. It is a consequence of over-federalization. I think the white-collar folks should make common cause with folks who are looking at other parts of the docket, and I hope to remain part of the dialogue if I'm not run over and crushed by the traffic coming from both ways. So thanks for allowing me to speak today.
Thank you to all of our speakers who have given us a lot of provocative material. I'm going to ask a few questions of the panel, and then in just a few minutes we'll open it up to questions and comments from the audience. Let me first ask John, and perhaps Brad also might want to comment on this. What about the argument, because of local relationships, the politically elected district attorneys or Commonwealth attorneys, state attorneys, whatever they're called, most of whom are locally elected, their relationship with other public officials, and also the lack of resources and expertise at the local level to deal with corruption cases. How do you answer that as a reason for the federal government to be involved to an extensive amount of prosecutions, investigations, and prosecutions?
Well, I think there's two answers. One, I mean, you can have the ability to cross-deputize in between U.S. attorneys and local law enforcement, and it is largely a jurisdiction question. But to me, the second point is more important. We hear DOJ talking a lot about the necessary enforcement against corruption, and yet my experience, having been involved in some of this, is that U.S. attorneys will not actually do the most important thing as far as corruption, and that is to make sure that elections are honest. And having come from Louisiana, I'm an expert on this just by having lived there. And as long as U.S. attorneys refuse to actually go in and monitor elections and make sure they're clean, which they will not do, then that's the real problem of corruption. If we have free elections, people will in fact either change the situation or they won't, but it will be democratically done. And secondly, as Madison explains in the Federalist, the real federal solution to this is quarantine. If a state is going to behave and vote for bad government routinely, it will destroy its image and its population will vote with its feet and move elsewhere. That is not the immediate fix that prosecutors may think is appropriate, but that is the kind of fix that the framers thought appropriate for a self-governing republic.
Brad, would you like to answer the question?
Yeah, in general, I don't have a big problem with the notion of federal criminal jurisdiction in the public corruption area. I do think there are cases where you can have a pervasively corrupt arrangement or compromised prosecutors in local jurisdictions where you do need the backstop of federal power to clean a situation up. Now, we shouldn't kid ourselves that the feds are entirely apolitical in how they will exercise that power. There's a risk on the federal side as well. But I think in the area of corruption and in the area of civil rights, there is a legitimate federal role, and leaving aside fatally vague statutes like the honest services statutes, I don't generally have a problem with federal corruption prosecution and civil rights prosecution.
Yeah, but there's a difference. There is the 14th Amendment that backs up the civil rights prosecutions. Tell me where in the Constitution there is a corruption clause that justifies this kind of interference.
If you're talking about the question of where there is congressional power to enact a statute that gets at state or local bribery, I'll confess to not having thought deeply about that question. My hunch is there's probably multiple answers. Maybe Noah knows it, having thought about honest services recently. I can imagine rationales under the Commerce Clause, for example. I can imagine rationales under the Republican Guarantee Clause, and I'm guessing there are others. But that's a question I haven't thought about a lot.
Noah?
Sure. If you look at the federal statutes that are used for state and local bribery, there are a number of them. There are a number of different constitutional hooks for those. Honest services fraud attaches to the mail and wire fraud statute. So there you have the federal mail, you have interstate wires. There are other statutes that attach to effects on interstate commerce. There are statutes that attach to federal funds. Almost all state and local governments take extensive federal funds, which I think those who want to see federal money well spent would probably agree confer some jurisdiction for federal prosecution. The Supreme Court has really never had a problem with federal statutes prohibiting corruption. They've had problems with specific statutes that were not well drawn, but not with the concept. And I do think that I really do disagree fundamentally with the idea that if you have fair elections, you're not going to have corruption. That there are plenty of public officials who were unquestionably fairly and popularly elected, who make all kinds of very poor choices to act corruptly and really betray the trust of those people who elected them. And it's very important to have tools to go after that. I also would say, as a former corruption prosecutor, I think one thing that is lost is that the vast majority of corruption prosecutions are not against elected officials. They're against people in various parts of the executive branch, at the federal level, at the state level, various parts of the bureaucracy who are violating the public trust, and there needs to be a way to address that kind of conduct.
Sara, do you want to get into this discussion?
I think most of the key points have been made. I do agree very much that you need to recognize that it's Noah's point, that it's administrative, whether it's within the bureaucracy, people exercising the ability to grant contracts, et cetera. That's a whole additional element where lots of money can change hands, where decisions can be distorted. So I think that's a good point. But other than that, yeah, I'm happy to let it go on.
Okay, let me ask a question of Noah. Why do you need an honest services statute at all, and shouldn't it be more specific, like bribery, like fraud, like kickbacks, so that the conduct is sufficiently devised or defined so that both the prosecutor and potential defendants know what the offense actually is?
Sure. I think, as first of all, why do you need an honest services statute? There were a couple of things that honest services fraud specifically allowed the federal government to get at. One was bribery and at the state and local level, which may not have been otherwise reachable. And that's sort of the discussion we just had. If you accept that that's something that's important for the federal government to be able to target, then that statute was a key way to do that. In other words, kickbacks. Putting those aside, because that's what the Supreme Court has preserved in the Skilling decision, there's another category of cases which are, I think, maybe appropriately described as undisclosed self-dealing. And so you might think of an example kind of like this. This is one that folks from the Justice Department have used, which is that you can have the mayor of a city who takes a $5,000 bribe to direct a contract to a certain company. Clearly that's corrupt. Everybody, I think, agrees that that's kind of conduct that you want to be able to go after. You can envision another scenario where that same mayor, rather than taking a bribe, secretly sets up his own company, doesn't let anybody know that it's his company, doesn't disclose that fact, directs that contract to his company, makes a profit from it, a personal profit, without anybody being aware that his decision-making was controlled by his own personal profit rather than by the public interest. In many ways, the same conduct. You could argue more serious conduct because the personal benefit is more direct. It might even be larger, and yet that's conduct that couldn't be addressed as bribery or kickbacks, could be addressed as undisclosed self-dealing. That's the kind of conduct that was covered by honest services. It no longer is. It's probably not covered for state and local officials or in the private context by anything at this point. I think I agree. Senator Leahy clearly agrees with your statement that it ought to be carefully defined and narrowly defined, and that's why the bill that he's introduced includes in mail and wire fraud undisclosed self-dealing, tries very carefully to define it, tries to narrowly define it, more narrowly in the private sector where there's I think a need for even more caution than in the public sector, but in both cases to be careful, to be precise, to be narrow. That's a work in progress, and if people have ideas about why it's not sufficiently narrow or precise, we're happy to hear about them.
May I chip in here too? I wonder also about gratuities, which are illegal for federal officials under 18 U.S.C. 201. So if you don't get a quid pro quo agreement in advance, but you know as the mayor or as whoever, if you send this bill somewhere else, you're going to get this lovely, whatever it is, invitation for the all-expense-paid week in Barbados or whatever. It doesn't have to have been a quid pro quo for it there to have been a corrupt influence, and every federal official is subject to that kind of limitation. That might also, if you have a jurisdictional hook, be the kind of thing, so that question, how far do we want to go in policing, if you will, state and local government officials, and would you pick up these parallels from regulations that we agree are a good idea for federal officials? And I think that's a good dialogue, right? That's clearly what the Senate is thinking about now. It can be extremely widespread on the part of the states, which is another factor that makes it difficult for state and local government officials to pick this up. In the Weirich case, the Alaska paper had published an account of the number of officials that had taken money from Vico, this big oil company, and a list of the ones that had taken the largest number. And as a result, the folks that were named and their friends had shirts and caps embroidered with CBC, for Corrupt Bastards Club. And they wore them around. There were more than 100 items embroidered by the Speaker, the House Speaker's girlfriend, for folks who were essentially flaunting, taking all this VICO money, right? And it was a kind of a public scandal, and the local authorities did nothing, right? More than 6 members of the state legislature, including Bruce Weirich and others, were prosecuted for all this money just flowing into and distorting the decisions of the members of the state legislature, even though there was apparently no, at least in Weirich's case, no clear bribe. But there were probably, if nothing else, probably gratuities flowing heavily there.
Brad, you want to respond?
Yeah, the idea that undisclosed conflicts of interest, concealed self-dealing, ought to be embraced within a narrowly targeted statute, I don't think is terribly controversial. Bribes, kickbacks, undisclosed self-dealing, those are all things that merit criminal punishment when they're done. The problem with the honest services statute was that it covered a lot more than that. I tried a case back in the 90s where a county commissioner down in Lee County, Florida, was convicted of an honest services count where she and the other defendant that we represented were acquitted on all other counts, including bribery, because she had lied to a reporter about an illicit love affair that she was having with a married man who was also a lobbyist at the time. And the prosecutor, we begged the judge for an instruction limiting honest services in this context to bribery. He refused. The prosecutor in closing argument got up and argued, she's a public official. When they asked her about the affair, she should have told the reporter the truth. That would have been honest services by your public official. And the jury, after the verdict, came out and talked to the press and explained that that's precisely why they convicted her on this single count where there had been a flat rejection of all other allegations of illegality, including bribery.
John?
Well, it is about jurisdiction, which Sara mentioned, and then Noah mentioned hook, and that's what the problem is. The Constitution is about jurisdiction, and hooks are about expanding that jurisdiction. And when you expand the jurisdiction of the federal government further and further, you are eliminating what's left of federalism. And the reality is, all of this is done with the best of intentions, but it really has to do with your constitutional viewpoint. That is, if you think, unlike Madison, that somehow some independent party, namely a federal prosecutor, is going to come in and make all things right, well, then you go to the complete centralization rule. But the premise of our Constitution is quite different, and it is that jurisdiction is to be limited, and part of self-government is the ability to choose bad government. And the federal government certainly has a role on commercial matters that go across federal and state lines. But none of these statutes are drafted that way. The wire and the mail fraud, as Justice Scalia has said in one of the cases, it's not mail fraud. Mail fraud was originally fraud through the mails. Now it is fraud plus some kind of hook to the mail. That's all it is. All of this is a pretense. We know it's a pretense.
Any other comment from the panel? If not, let me ask Sara. question. Isn't there a real danger in many of the federal statutes where civil law concepts such as respondeat superior or vicarious liability and strict liability are brought into the criminal law, thus changing entirely the way in which these cases can be brought and the quantum of evidence necessary to convict?
Well, absolutely. I mean, I'm sure Brad could tell you that if he's trying a case and it's strict liability or respondeat superior, it is going to change what the prosecutor has to prove. We do have a pretty long history now in the United States of public welfare offenses that are strict liability offenses. And in fact, all of you know from first-year criminal law, bet you remember that, from first-year criminal law that there was actually a fair amount of strict liability for important offenses at common law, felony murder being the most extreme example. Right? So the question is, when are you going to employ strict liability? When is it appropriate? And respondeat superior for entities. I was interested to find that that many Western European nations are adopting respondeat superior for corporate criminal liability. It's adopting it anew in the past 20 years. So I think it's an option that's on the table. Noah really gave me a nice line here. We have to be smart about it. I wouldn't take strict liability or respondeat superior off the table. It's very powerful medicine where you use it. Right? And I would not say never, but certainly the trend is to, and the big picture idea is that ordinarily criminal liability requires fault as measured by culpability, by mens rea. That ought to be the normal standard. You ought to depart from it very infrequently. So I think that's right. And then, like corporate criminal liability, I wouldn't take respondeat superior or strict liability off the table, but I'd scrutinize it very heavily. And I think it's time for a thorough review of the federal criminal. John and I can hardly stand to say code, because there really isn't a code. All that grab bag of these thousands of offenses, and I'm sure some of them we would conclude that strict liability is not justified, and that we would need to cut back on it.
Brad, would you like to respond to that?
Well, I don't find particularly persuasive the fact that Europe is slowly following us down the primrose path and grafting more corporate criminal liability into their body of law. They're doing it for the same bad reasons that we did, basically as a way to impose a surtax on companies to extract additional money from corporations. The way our system is operating now, it's tens of billions a year taken out of industry's hide, and prosecutors are often every bit as much motivated, if not more, by the prospect of an eye-popping multi-hundred-million-dollar settlement that they can announce and get an Attorney General's Advocacy Award for, as they are by any real federal interest that would be served by criminally prosecuting these companies. Europe is following us in the direction of class actions too. And I'm not sure that the fact that Europe is doing something after we are provides a real argument against it. In fact, I might take the opposite proposition just to be provocative. The serious argument that Professor Beale makes in favor of having corporate criminal liability is that the corporate form allows you to wreak unique havoc. Companies are more powerful than individuals, and so they can create certain types of harm that mere individuals could not. I don't think I'm convinced that I would go all the way toward completely abolishing corporate criminal liability, but if we limited corporate criminal liability only to those situations where there had been some egregious harm that could only be perpetrated through the corporate form, we would be taking the current universe of corporate criminal liability and cutting it by 95 or 97 or 98%. Now, I might cut it still further based on some other criteria we could discuss, but if you're worried about unique harms caused by the corporate form, why not just limit corporate liability to those limited cases?
So let me explain why you might want to think about Western Europe. There's a whole strain of, those of you who love law reviews can go out and find these articles yourself, but there's a whole strain of writing that suggests that there's this American exceptionalism hanging on to this relic of discredited English common law, that it's like the deodand, like
blaming the cart and the horse for the accident, and you kill the horse and you chop up the cart because some individual was injured, and that there's nothing more to corporate criminal liability and respondeat superior than that, and we ought to be embarrassed that we have not gotten rid of this superstitious, outmoded relic. And I do think that the experience of Western nations pretty thoroughly discredits that idea. Now, at that point, why are they doing it? And it's a longer discussion, isn't it? What is the felt need for? Are they really doing it to raise revenues, or are they seeing that there really are dangers? And in a lot of countries, you can trace it to specific serious incidents where other legal remedies were found to be grossly insufficient, and they wanted another tool in the toolkit. So I think we can have a discussion about whether the experience in other places suggests that there would be a missing set of elements to respond to serious kinds of harms that have been caused and we're afraid will be caused in the future by corporate behavior, and we need that tool.
John?
At the federal level, we really don't know what a crime is. I mean, we don't have definitions of what crime is. And we call anything that has a criminal penalty a crime. Well, that's nonsense. Why? There's a difference between regulating something and prohibiting something. Take gambling. If you prohibit gambling, you're saying that gambling is wrong. If you legalize gambling and you regulate it, you're saying it's okay, but it is a violation of a regulation if you don't do such and such. We don't understand at the federal level the difference between crime, which is prohibition, which carries moral stigma, as opposed to a regulation, which is a legal violation. There are some people, one of the panels I was on a few weeks ago where the professor said, running a stop sign is a crime. Well, that's nonsense. It's an offense. And what we need is a definitional distinction between crimes that require mens rea and an act and causation and all of that stuff you learned in basic criminal law, and other categories that call them offenses and give them punishments and everything else, but distinguish what is really a crime and carries stigma and what isn't. And that's basically, a lot of prosecutors simply want to get that stigma on there. And putting a stigma on a corporation that's not a person not only makes no sense towards the corporation, what it does is to undermine the whole notion of what really a crime is. Listen, today, look at people like Martha Stewart and Spitzer. I mean, being a criminal in this country no longer really means much. And if that's the case, we're not only going like, it's not just Europe following the US, we're getting like Latin America. Why? Being a criminal down there doesn't mean anything. And by the way, they criminalize all kinds of corporate practices. So until we understand what really is a crime, this should not be simply civil litigation where the prosecutor has the moral stigma stamp, because all it is civil litigation with a whole lot of leverage and moral stigma given to DOJ. That's all it is.
Noah?
I guess a couple of points. And one is on the issue of this sort of increasing vast number of federal crimes. I think a point that is sort of elephant in the room that you have to acknowledge is that one of the key issues here is the politicization of crime. Is that it is very easy to pass laws with new crimes. It's very difficult to consolidate, reduce, eliminate. You saw there was just ended up being not only bipartisan but consensus piece of legislation to reduce somewhat the disparity in sentencing between sentences for powder cocaine and crack cocaine. That was a decade-long project with lots of politics before it actually got done. And as long as you have people politically attacking other politicians who are sort of trying to take a serious look at these issues for being soft on crime, you just never. This is all academic discussion. That's one point. Moving to the corporate crime issue, and again, that's not to say. I think you do have to be smart. I think there are cases where new crimes are appropriate, and cases where existing statutes are inappropriate, you have to be able to really appropriately analyze that without, without some of the rhetoric. On corporate liability, I think there are a couple of issues. And one is the one that's already been discussed, which is that corporations can have a unique ability to cause problems. There certainly have been recent instances where we've seen that. Another one is deterrence. I mean, is that the ability to prosecute corporations criminally has a tremendous deterrent effect. And if there are issues where we agree that a certain kind of conduct is a problem and needs to be addressed, it's an effective way of addressing that. I'm not sure that the kind of balance of power is quite as was described. I think Sara made a very good point in that in all prosecutions there is some imbalance. Corporations have much better lawyers and a lot more of them than most defendants do. They have immense control over their employees. They have the ability to protect their employees when appropriate, and often sell out their employees when appropriate. They have a very strong role in the process that most defendants don't have. None of that justifies inappropriate pressure on corporations. And Senator Leahy worked with others on both parties to try to push against, for instance, the pressure on corporations to waive the corporate attorney-client privilege, and that issue was in many ways effectively dealt with. But in those instances where there is a real problem and where you want to deter serious conduct, the ability to prosecute corporations for serious violations seems to be a reasonable way to go at it.
May I make two quick points in response? The politicization point, I think probably all four of us agree with here. Just as an example for you all to think about, the recently passed financial reform legislation, the Dodd-Frank bill, contained more than 24 new business crimes in it. It's a very easy place to go if you want to show that you're serious about something. Which gets us to the second point, deterrence. The question, it's absolutely right that the threat of criminal investigation and sanction for a company has a powerful deterrent effect on the companies for the reasons that I spoke about when I was making my initial remarks. The question you have to ask yourself is it the right level of deterrence, or is it over-deterrence? Is it chilling productive, legitimate business activity? There's no single answer to that question. It has to be looked at on a case-by-case basis, but I would argue there's far more over-deterrence than proper deterrence, because the measure of the deterrence introduced by the criminal law is the difference between the deterrence you get by prosecuting individuals and imposing civil liability on companies, which is already quite considerable, and then the extra from prosecuting companies criminally. And that extra margin, I think, usually is more harmful than helpful.
John, a short response, because I want to get to the audience.
Deterrence assumes a rational calculation, and you can't make a rational calculation unless you know what's prohibited.
Okay, let's turn to the audience now and get your questions or comments. The microphone there, just feel free to line up behind the microphone.
Thank you very much for your presentation. I think that a lot of these times when we speak about over-federalization of crime, we do get more sympathy for the wealthy and the powerful than we do for the ordinary criminal defendant. I do think it's an interesting dynamic. My question on the corporate side is, beyond the power of a corporation, another reason why federal criminal law is needed is so that corporations do not engage in wrongdoing as a calculated business philosophy. For instance, there was reference to hundreds of millions of dollars settlements of the Justice Department. Well, many of those hundreds of millions of dollars settlements are against drug companies. There was a discussion about drug companies. Well, drug companies are not allowed to promote drugs for uses that the FDA has not approved. But they do it, and they do it because the amount of money that they can make for doing that as a cost of doing business, if they're never prosecuted, the civil liability isn't going to, so they pay back what they did wrong. If there's not criminal liability, then corporations will do things as a cost of doing business that we don't want them to do. Is that a non-controversial or a controversial statement?
Okay, Brad?
Well, it's interesting that you raise off-label promotion, because I think off-label promotion is kind of an object lesson in over-criminalization. It is the rare off-label promotion case where there is compelling evidence that the drug company advertently set out to promote its product for something the FDA had not approved because it made a rational calculation of risk and benefit, decided it wanted those extra profits, and was willing to roll the dice on enforcement. Such cases exist. There have been some of those. But the more typical off-label promotion case, and I know because I've defended some of these, is far more ambiguous than that. Eli Lilly was accused of promoting its drug Evista off-label. That's an osteoporosis drug. It turns out that clinical research established beyond any doubt, the federal government's own scientists agreed that this drug also reduced the number of breast cancers in women who were taking it by 2/3 from the incidence of breast cancer that would have otherwise occurred. So Lilly told physicians in the course of promoting the drug for osteoporosis about this other health benefit of the drug. The Justice Department came after them, saying they were trying to sell the drug for breast cancer prevention rather than osteoporosis. I am morally certain that if Lilly had had any ability to go to trial, it would have been acquitted. The jury would have been out less than an hour for saving 2/3 of the women taking this drug who would have otherwise developed breast cancer from getting that disease. And yet Lilly was essentially compelled by all of the pressures that I just described to enter into a $38 million settlement with the Justice Department.
Well, I'll give you a counterexample, and you already conceded that they range, but Pfizer pled guilty and agreed to pay $430 million to resolve both civil and criminal charges on off-label advertising and prescription of an epilepsy drug, and the finding was that patients, for ailments that it wasn't approved by the FDA, and they had studies showing the drug was actually no more effective than a placebo for some of those other conditions. So that's quite a contrast to the breast cancer, finding that it was effective, and at least press reports found that 90% of the drug sales were for things that were not approved treatments. So, asking a company to forego 90% of their sales unless there's a big deterrent, there is an incentive, and the question of how you push back against that is a significant one.
Quick responses. Noah?
Sure. I do think that, sort of agree with, in some ways, everything that was said, that it is important that misconduct, particularly where people's health and safety is in question, not be kind of something that a conscious decision that corporations may make where civil fines are a cost of doing business. If you look at the salmonella outbreaks over the summer, in the case of with eggs, one of the companies that may well have been the root of that had hundreds of violations, paid hundreds of fines, appears to have continued to keep doing what it was doing. My boss has a food safety amendment on that may be pending today to increase criminal penalties, and the argument there is that where there is intent, and this is where I agree with Brad, where there is a decision made to put people at risk, it has to be more than just the cost of doing business. The risk of criminal penalties can be that extra amount that changes behavior.
John, very quick, because I want to get these two
Off-labeling
questions
is a
in.
bad example because unlike in many corporate situations, you can actually identify the perpetrator and there's no reason why you couldn't personally indict that person. And as far as deterrence goes, if you indict enough of them, you are not going to have anybody applying for those positions.
Next question.
Thank you very much for an excellent panel. I'm just back from several months in Colombia, and I think I'm seeing a sort of a scissors action with the way we're incentivizing behavior. Are we and I'd like the whole panel to respond, anybody who wants to on this. Are we incentivizing, on one hand, the over-enforcement by forfeiture of property anytime that there's a successful criminal federal prosecution? We're doing that, incentivizing people in the United States. And in Colombia, we're incentivizing narco-traffickers by putting a huge profit in the production and marketing and distribution of illegal drugs.
Okay, quickly, since that's a topic deserving of a whole panel on itself, what comments here?
I was looking at John. I thought, as the former, prosecutor on this.
John?
Well, I mean, I've worked in Latin America a little bit, and the problem is that, unfortunately, our criminal justice system is going the way of Latin America, and that's not a good sign.
Anybody else?
I will say there is evidence that forfeiture, the availability of forfeiture, can really distort prosecutorial decision-making. And the evidence that I'm most familiar with is at the level of state and local enforcement, where either under state law, the state and local enforcement authorities retain those assets, or under federal asset sharing if the if the state and local authorities assist federal prosecutors and investigators, and there's a conviction and a forfeiture, a federal forfeiture, it'll be shared back and it will go to those enforcement authorities. And there's some quite scary stories and studies of how, and it's probably going to get worse with pressures on local budgets, how enforcement authority is shifted from what priorities otherwise would be to bring in revenues. It's a revenue stream, and that, I think that is a big concern, and it actually has federalism implications as well. Many states have protective laws that are intended to undercut those incentives to enforcement authorities by, for example, sending the assets. In North Carolina, forfeiture assets go to the statewide education fund. So if you're an enforcement, if you're police or you're a prosecutor, you should only do a forfeiture when you really think it's appropriate and prosecute that individual and seek a forfeiture, because you don't get any benefit from it. It's going to go to the state fund. But if you take that case across the street to the federal prosecutors, they prosecute it as a federal offense, the money comes back to the state and local law enforcement folks. So there's a distortion not only of who gets prosecuted, but whether you take a case to the feds, because it will do an end run around state law, which I think is probably in this group. You can see that that's not really a good idea.
When that's done, how is that any different from some of the other conflicts of interest that we've said have to be prosecuted?
Yeah.
Why isn't this corruption? Why aren't law enforcement engaged in corruption?
Well, I actually think there's a really good argument that that there is a kind of serious professional impropriety. Now, I don't know that they're using mails and wires and whatever else is involved. They're not seeking to benefit themselves directly, but it really is a distortion of authority. It also lets them get around exemptions, like if you have a bigger homestead exemption or something, it doesn't apply under federal law. So they're evading state law restrictions by taking it to the federal side.
There's actually a due process problem
Yeah.
with this. I mean, there are Supreme Court cases where the local judge was found to have acted unconstitutionally by adjudicating traffic violations because the revenue from those violations supported his function in his court. This is no different. And we haven't even talked about the bounty provisions. I mean, Dodd-Frank enacted a bounty provision. It isn't even a qui tam. Someone who now comes into federal prosecutors and reports securities law violations that they then prosecute is statutorily entitled to receive not less than 10%, not more than 30% of whatever recovery the feds make if it's above a certain threshold. Talk about distorting your prosecutorial incentives and your mix of enforcement. Right. I mean, it's unbelievable. These private bounties, people are going to get rich from them.
I think you've illustrated that this topic does deserve its own panel at some future Federalist Society meeting. But excellent question. Let me just say, I think we would probably all agree that prosecutions should not be profit centers. And now the last question.
Hi, thank you very much. Tiffany Jocelyn from the National Association of Criminal Defense Lawyers. The panelists spoken about vicarious corporate criminal liability's deterrent effect. I'm intrigued by that concept because in this system, even if you have the most vigorous compliance program, if you do full reporting, no matter what you do, you could be angelic. If one employee, rogue employee, does something wrong, you have no defense. So to me, not only does that undercut the concept of deterrence, because how can you deter something if no matter what you do, you can still be held accountable, but it actually, in my opinion, encourages a lack of compliance or vigorous compliance because you may not want to detect it because then you have to report it. So I'd be interested to hear what the panel has to say, and I think it's the UK, does have a defense for compliance programs. So how vicarious corporate criminal liability actually acts as a deterrent when we have no defense in our system.
Yeah. Let's start with Noah.
Sure. I guess I think, at least in my case, that may be conflating a couple of different things that I was talking about. I think that corporate prosecutions can serve an important deterrent effect. I don't think that comment was meant to apply to cases of absolute vicarious liability. In other words, there are a lot of corporate prosecutions where there is a requirement and there's proof of a level of corporate culpability, of knowledge at high levels, of policies, of practices where it is appropriate to apply liability to a corporation. And in those cases, the deterrent value is important, that it's not just money, it's not just an item in the balance sheet. Instances where you're talking about sort of pure respondeat superior, where one low-level employee's conduct can bind an entire corporation, I think that's a different analysis. And I think that there may be cases where that's appropriate, but that is, I think that's very different than at least what I was talking about in terms of the importance of deterrence.
Well, I always wonder about that example because people don't very frequently provide examples of one rogue employee. So the Pfizer case wasn't a single rogue employee, right? And it was systematic. And I guess you could try to bring hundreds of prosecutions against those drug salespeople. But this is not a very effective thing to do. What you really want is to be able to hold the entity that created that pressure to do that incentive to not want to do that. And so, I think the question whether it is important to create such a defense, to make it formal, whether we think it's sufficient that that's an important part of prosecutorial discretion in these cases, how you write it in. Certainly if the corporation has not only wanted to do the right thing, but has lots of mechanisms in place to do that, most people, I think, would think that that's part of the discussion with the prosecutor when you say you're pleading and so on. And if there's nothing more to be done and it really is one rogue employee, have you seen prosecutions?
Right now, a corporation's compliance program is only formally taken into account at the sentencing stage.
Formal.
But even informally, most big companies have robust corporate compliance programs. Are they perfect? No, nothing that big and that complicated is ever going to be perfect. But most companies are trying hard not to violate the law. And I think the questioner makes an excellent point. It undermines the deterrence rationale to realize that there is this vicarious liability. The model penal code actually does not have it and suggests that corporate criminal liability be restricted to situations where there's either senior management involvement or corporate policy, some evidence suggesting that there's a corporate policy. That's a much more sensible rule from the perspective of deterrence. And interestingly, our own Supreme Court in the civil context, in a case called Kolstad, basically said that punitive damages, civil punitive damages, are not appropriate where a company has done its level best to avoid violating the law. So you're actually more exposed on the criminal side than you are on the civil side from this perspective.
Most of these federal criminal prosecutions of corporations are not the gigantic corporation that has no idea what the 4,000. So 79% of the corporations sentenced in FY08 had 50 or fewer employees. These are mostly small groups, and people know what's going on. Now, so, you know, you have a theoretical problem, I think, more than a real problem. That doesn't mean you shouldn't solve it. There can't be exceptions. But these, you know, a large multinational corporation being prosecuted because of one rogue, you know, show me the case.
Anybody else wish to comment? Okay. I think you would agree with me that this panel has had one of the most high-level and knowledgeable discussions of this topic that I've seen in a long time. So please join me in thanking them.